Good morning. I'm Kenneth Petroulis, the current chair of the Foundation's annual Rule of Law writing competition and a principal at Petroulis Fiduciary Services. For 17 years now, my wife Dale and I, believing that the respect for the rule of law is necessary, now more than ever, have sponsored this competition. Today, I'm delighted to introduce our speaker, Piper Hinson, and our program moderator, Matthew Kanan. Piper graduated magna cum laude from Southwestern Law School, where she served as editor-in-chief of the Southwestern Law Review and academic chair of the Moot Court Honors Program. Both of her moot court teams earned Best Brief honors at competitions. At the ABA National Appellate Advocacy Competition, Boston Regionals, she was named Best Advocate. Her team won the regional championship and moved on to compete at the nationals. She also served as a Dean's Fellow, Research Assistant, Teaching Assistant, and extern to the Honorable Otis D. Wright II at the U.S. District Court for the Central District. During her final year, she participated in the Appellate Litigation Clinic, where she helped draft appellate briefs and argued a case before the Ninth Circuit Court of Appeals. Matthew D. Kanan is of counsel to Ruttenberg, Cutler, Broomer, LLP, where his practice focuses on trust and estate disputes, conservatorships, probate and trust administration, and civil appeals. He holds the distinction of being a certified specialist in estate planning, trust and probate law by the State Bar of California Board of Legal Specialization. And now, Matt, let's get started.
Hello, everyone. Good morning and welcome. It is my great pleasure to moderate this presentation by Ms. Hinson, who is our winning author for this year's Rule of Law writing competition. Her article is entitled "Biting Back Against Animus: Gender-Affirming Care Bans Enacted with Animus are Unconstitutional Under the Rational Basis with Bite Standard." Some of you may already know what all of that means, and for any of you who don't, you're going to find out. Before we begin, though, I think this is a really interesting topic. It was one of my favorite papers that I have ever read in the more than a decade that I have been judging this competition. I don't tend to speak freely in superlatives, so I want to start by asking you, Ms. Hinson, what inspired you to write about this area of law?
Sure. If we can skip a couple slides, just so everyone can see. So well, first off, thank you for having me. This is such an honor to be here and to get to speak about this article that I'm so proud about, to have written and to be talking about today. When I was in law school, I was in moot court, as was mentioned, and my first moot court competition was the Wagner Labor and Employment Competition in New York, and it focused on a transgender basketball player. And that to me was a new area of law that I just hadn't known about it at all. And so that got me interested in the topic. And then at Southwestern, they offer a transgender law class. And so I took that class with Professor Amanda Goad, and I found that there was this really just a huge area of law that I had so little knowledge about, and I had so much to learn. And so that's what really got me kind of passionate and excited about this area. And I thought there's a real void in advocacy, I think, because it's just sort of new. It's all really kind of started in 2020. And so I took that as this is my opportunity to get involved in this newer area of law. And it's something I'm now very passionate about. If we can skip to the next slide, the big spark for this article, though, was when I finished that class. My wheels were spinning, and I was in law review, and one thing that they ask you to do is write a law review article, a student note. So I thought, okay, this is an area of law I like. Let's dig into it. And I noticed that there was a sort of a divide in how courts were treating certain challenges. Gender-affirming care bans had been challenged in court, and there was a divergence in how the district courts were handling it versus how the circuit courts were handling it. And so that was really interesting to me because I thought maybe there's another solution aside from what these two levels of courts have been applying.
Do you want to just take a moment and define for anyone in our audience or later rebroadcast who is unfamiliar with the term gender-affirming care?
Sure. There's actually a bunch of terms I think we should talk about. So next slide, if you would. I think the first two terms to get sort of clear on are cisgender and transgender. A cisgender is a person whose gender identity corresponds with the sex that was given to them at birth, versus a transgender person is someone whose gender identity or expression is different from their sex assigned at birth. Next slide. Gender identity refers to a person's internal understanding of their own gender, or it's a person's how they identify. And your gender identity is typically what you're given at birth. So that's determined by external genitalia, and that's not what you think, it's just what the world has decided on you. A transgender person's gender identity differs from the sex assigned at birth. And so that's the sort of big distinction, whereas a cisgender person's gender identity aligns with their sex assigned at birth. Next slide. So gender dysphoria is the feeling of discomfort that transgender people might experience. This is where their gender identity differs from their sex assigned at birth, and this is the unease and dissatisfaction that results from that feeling. It can lead to depression, anxiety, and self-harm, and have a very harmful effect on anyone's daily life. Next slide, please. So what is gender-affirming care? This is the big topic right now. This is what the article really focuses on. And gender-affirming care for transgender minors is a big spectrum. It can vary from socially affirming changes like changing your name, your clothing, and your pronouns, all the way up to more comprehensive measures like puberty blockers, hormone treatments, and sometimes and rarely surgery. Next slide, please. So this is the WPATH, the World Professional Association for Transgender Health, is sort of the main authority on care for transgender minors. And it's established gender-affirming care treatments as the proper standard of care for gender dysphoria. This is used to treat children who suffer from gender dysphoria to improve their outcome, because when transgender minors are not allowed to receive gender-affirming care, it can be detrimental. As I mentioned, self-harm, but it can be attempted suicide or completed suicide, which is obviously the worst case scenario. Next slide, please. So the gender-affirming care treatment has been under fire recently with states enacting gender-affirming care bans. So these bans are prohibiting transgender minors from receiving these life-saving treatments, such as puberty blockers, hormone therapy, and on occasion surgery. So what I noticed, though, is this is not going unchallenged. Parents and advocates for trans minors have challenged all these laws in court, and they are mostly filing preliminary injunctions to stop the enforcement of these state laws. Next slide, please. So this is just some general big picture background information. The UCLA Williams Institute is a really helpful resource that I used quite a bit in my article. As of 2025, they estimate that in the United States, about 724,000 youth identify as transgender. And this number is it's about 2 to 3% of the population of minors, and that's age 13 to 17 years old. And they have particularly high rates of poor mental health outcomes compared to their cisgender counterparts. So, for example, before all of these gender-affirming care bans started popping up, which really happened in about 2020, 2021. The Center for Disease Control and Prevention conducted a survey in 2017 and found that more than a third of transgender high school students were attempting suicide in the past 12 months. And that was a rate 4 to 6 times the rate of their cisgender counterpart and peers. And that is a pretty big difference. And so to me, that shows these treatments are helpful and they can help prevent really, really harmful outcomes. And these higher rates of attempted suicide are likely from the social rejection, the lack of support from parents, and bullying, and all the things that go with a stigmatized group. Next slide, please. So I mentioned these state laws banning gender-affirming care. These are all within the last couple of years. And so in particular, as of 2024, at least 26 states have enacted some form of gender-affirming care bans for minors. We will talk about the Supreme Court case soon, but we'll just keep going. Next slide, please. So I mentioned this is one of the things, the challenges that have been coming up. Most of the challenges are coming in the form of an equal protection challenge. So they are bringing them these preliminary injunctions, which, as we all know, requires the 4 elements. You have to have a likelihood of success on the merits. The plaintiff will suffer irreparable harm. The balance of equities supports the injunction, and it's in the public interest. These court challenges all really hinge on that first element, the likelihood of success on the merits of the claim. Next slide, please. So, as I mentioned, the courts have really struggled with which standard of review to apply to these equal protection claims. Next slide, please. Now, the main 3 standards of review are the 3 big ones. We have rational basis review, intermediate scrutiny, and strict scrutiny. Rational basis is our most deferential to state laws and state legislatures. Intermediate scrutiny, typically for sex-based classifications, and then strict scrutiny is our highest standard, and it's the hardest to satisfy. Next slide, please. So what has happened is typically, not all, but most district courts found there was a quasi-suspect class for these gender-affirming care bans. They applied intermediate scrutiny, and the laws did not pass. So they were finding and granting these preliminary injunctions because it didn't satisfy intermediate scrutiny. Next slide. And then, by and large, with the exception of maybe one circuit, the courts of appeals they found that no, there isn't a suspect classification. There's no quasi-suspect classification. And they found that rational basis was the proper standard, and they were reversing the preliminary injunctions. So they applied this very highly deferential standard of review to the state laws and found that no, they satisfy it. So next slide, please.
This deferential standard of review is concomitant with the presumption of constitutionality. So as a challenger seeking to roll back a state law or federal law overreach against a protected constitutional right, the higher scrutiny would basically serve like a burden-shifting presumption and would be a great advantage to the challenger that the burden of proof be on the government to justify its law, rather than the burden of proof be on the challenger, presumably with less resources than the government, to disprove the validity of the law.
Yes, and that's one reason that when they get to rational basis, because the burden is on the plaintiff, it's tougher to satisfy because less resources, it's the uphill battle for them, and there's a presumption that the government has a legitimate interest.
And typically, if you go over the history of the cases and you analyze many of these in the paper, if rational basis review is found to apply, it is essentially the same as saying that the law will be found constitutional, but not
Yes.
always, right?
Correct. Yes.
And
But
you're going,
by and
that's what you're
large,
coming
yes.
to.
Yes, which is yes, this is where my idea comes in. So we'll first off talk about the elephant in the room, which is US versus Scrimetti, which was the case that came down from the Supreme Court last year in June. So it was from a Sixth Circuit case which had held that this gender-affirming care ban SB1 does not classify on the basis of sex and decline to recognize transgender people as a suspect class because they're not, quote, politically powerless nor a discrete group. So when it went up to when the Sixth Circuit case went to the Supreme Court, they affirmed that decision. So they affirmed the rational basis review standard of scrutiny, and they said that the SB1 classifies on age and medical use and not sex or transgender status. So this case did resolve the split as far as whether it's rational basis or intermediate scrutiny based on a sex classification. Next slide. But what it kind of left open, I think, is this animus argument. It didn't decide whether an animus-based rational basis with bite claim could still succeed against a particular ban, because their focus was all about the sex discrimination classification. And I think that because these gender-affirming care bans are enacted with animus, that the correct standard of review is rational basis with bite. And under this standard of review, these gender-affirming care bans are unconstitutional. Next slide, please. So the rational basis with bite standard of review is not used a lot. It is sparsely used. But it sort of was announced spontaneously from this case from 1985, the City of Cleburne versus Cleburne Living Center. And in this case, it was basically, it involved a group home that was catering to mentally disabled individuals, and they were trying to get the permitting for their facility. The City of Cleburne was requiring them to get a special use permit that they weren't requiring other buildings to get. So in this same area, there were apartment buildings, sorority houses, dormitories, lots of other multi individual homes or uses. And so the Supreme Court, they examined all the reasons that the government gave as far as why they were requiring the special use permit. And in the end, they were able to eliminate every reason that they gave. One they had said was to avoid congestion and too many people, basically. But then the court said, well, you have a sorority house and apartment buildings, like you're going to have congestion from those other uses, so that doesn't work. And it sort of went through, example by example, and they said these are not legitimate interests. And in the end, the court said that there's no rational basis for believing that this living center would pose any special threat to the city's legitimate interests. Further, they said irrational prejudice is never a legitimate state interest. So they applied rational basis review, but it still had a little bit further scrutiny. And even the concurrence in Cleburne noted that this is really something more than just rational basis. And they called it second order rational basis review. So the concurrence recognized, yeah, it's rational basis, but it's still more. And other cases that have applied rational basis with bite, they know it's rational basis, but they will still say, it's a little bit more than that, isn't it? The concurrence from Justice O'Connor in Lawrence v. Texas, she also recognized this is actually a little bit more. So it's never really been flat out said this is rational basis with bite, but it's been acknowledged by the Supreme Court.
And of course, between Lawrence and Cleburne, you had Romer against Evans, where Colorado's Amendment 2 was struck down, notwithstanding the rational basis review.
Yeah.
And for anyone who, since that's not in your article, the site for that is 517 U.S. 620 1996 case.
Yeah. Next slide. So I've been talking a lot about the divergence in the courts, and I have Alabama and the case that went up to its circuit court, the 11th Circuit, as an example. In Eknes Tucker versus Marshall, the Alabama District Court found that its gender-affirming care statute violated the Equal Protection Clause because it said that the act prohibits transgender minors and only transgender minors from taking transitioning medications due to their gender nonconformity. So it found sex-based classification and applied intermediate scrutiny. Then, when it went up on appeal at the 11th Circuit, the court held that transgender status is not a quasi-suspect class and doesn't trigger heightened scrutiny. So then it reversed on rational basis. Next slide, please. So this is my argument that rational basis with bite is still one other option. So even without finding a suspect classification, you can still apply a form of heightened scrutiny. And this standard exists. It's not applied all that often, but it does exist, and I think it can be used when, in particular, there is a statute that's enacted with animus. Next slide, please.
Before you move
So
on to
this-
this slide,
Sure.
I want to join some dots for our viewers and listeners that, as a matter of timing, your article was published before the Supreme Court decided the Scrimetti case that trans discrimination was not gender discrimination.
Yeah.
And so regardless of our personal agreement or disagreement with that proposition, what you are seeking to do is essentially continue your advocacy that there are still ways forward, but this is a significant development since you went to press.
Yes, the Supreme Court decision came 1 week after my article was published. I knew I was on a tight timeline because I had heard oral arguments, and so it was important to get the article published ahead of it because I didn't know what they were going to say. But I think that this is still a really valid path because I will say when I started thinking about this idea, I did wonder, should I go and argue for intermediate scrutiny and say that, should I go that route? But as I was researching and thinking about it more, and I was just trying to think of another way because I was seeing what happened in the courts already. We were already seeing district courts applied intermediate scrutiny, and the circuit courts, by and large, were reversing. So I was anticipating that could be affirmed by the Supreme Court, and that's where I was in law school, so I just learned about a lot of this constitutional, all the standards of review, and so this was fresh in my mind of, well, maybe this is a way. Maybe this is a way to still find them unconstitutional, but not in the same way we were trying before. So I've been trying to think outside the box, and this was the idea for this. But this is sort of the roadblocks are, it's unclear. It's sort of untested. It's been applied, probably 10, 15 times in Supreme Court cases. So how to establish animus, that's a trick. It's not really defined anywhere. There are several law review articles and legal scholars that have kind of honed in on certain things. Dale Carpenter is one that I used quite a bit for my article. I relied on his work. He sort of picked out a few things. And one way we can do it is to scrutinize the text of these bills, the context of like who drafted them and what was happening, the process, the general impact, and then the government's claimed purpose, I think, is another thing to think about. Next slide, please. So in my article, I identify two big ways I think you can identify animus in gender-affirming care bans. The first is that the purported reason that they give is not the actual reason. A lot of these laws will claim that it's to protect children from experimental treatments, but then they will still allow exceptions in the statutes of how other minors can get the same treatments. So to me, that undercuts that argument. And then the second big reason is this context argument that you have the same state senators or representatives are the lead sponsors of multiple anti-trans bills proposed in the same year or nearby years. Next slide, please. So this is an example of one of the claimed purposes that I think is faulty. Alabama's gender-affirming care ban, their claimed purpose is to protect children from experimental medical interventions that have no proven benefits and carry with them substantial risk of long-term irreversible harm. Their act specifically talks about that. So it says, no person shall engage in any of the following practices for the purpose of attempting to alter the appearance of or affirm the minor's perception of his or her gender or sex, if that appearance or perception is inconsistent with the minor's sex. Okay, so that's what the bill says. Then, if we go to the next slide, this is one of those exceptions. So this doesn't apply to a procedure undertaken to treat a minor born with a medically verifiable sex disorder or disorder of sex development, such as being intersex, or another disorder of sexual development determined by a physician. So in effect, this exception allows for cisgender minors to get these treatments that they're claiming are untested and experimental. And like the district court had said, I believe in the Eknes Tucker, it was just not allowing transgender minors to get these treatments. That's where the distinction comes from. And this is how you can see that their purpose is actually a farce, because if you're saying something is dangerous for minors, it's either dangerous or it isn't. And these exceptions show that it isn't actually dangerous.
It's interesting how the same procedure can be experimental and dangerous when it is done in aid of a group of people that is different from traditional appearance norms, but perfectly safe when it is to validate those traditional viewpoints, isn't it?
Yes, exactly. And that's where you can kind of see, okay, I'm starting to see animus building here, because that doesn't check out. Next slide. So that's the first way I found. The second way is the context. And this is, I did sort of a study of as many states as I could, but this was one that stuck out to me. The same state sponsor for a gender-affirming care ban was also the same state sponsor for an anti-drag performance bill. In 2023, in the 94th General Assembly in Arkansas, State Senator Gary Stubblefield was the lead sponsor of these two transphobic laws. So this is just one example. There were many, but and in my article I bring up a couple others, but this is one. So next slide, please. So I'm talking about context. So when we look at the actual language in these bills, there are a lot of parallels that you can kind of see. They're just mapping over the same language and putting them for two different purposes. So, for example, in the anti-drag bill, that the original language, albeit not the final language in the bill, but one of the drafts talked about this highlighted language where it exhibits a gender identity that is different from the performer's gender assigned at birth. Now, that's something we talked about earlier, which was the terminology of your gender identity is different from your gender assigned at birth. That's what a transgender person is. And that language was pretty similar to the gender-affirming care ban language. You can see it echoed again in the highlighted section, gender that corresponds to his or her biological sex to identifying with and living as a gender different from his or her biological sex. So again, it's only focused on this, like the banning part is if you're living in a gender that's different from what you were assigned at birth, that's the bad thing. And so that's why when we look at the language of multiple bills and it's echoed in all of them, it's not probably about the thing it says it's coming from animus instead.
I think you've offered, Piper, some great tools for colleagues here who may have to litigate or perform the act of judicial review of these types of laws in a post-Scrimetti world. Not everybody who reads your article or who is watching or listening to us today will have the extremely important task of being an advocate for these rights, but as it is an increasingly prevalent and popularly accepted part of society that trans people do not have to live closeted, it is increasingly likely that members of the bar, the judiciary, and the public will encounter an increasing diversity of people in their lives and practices. And I think you also have some practical advice for all counsel, judges, and scholars of this area that you wanted to share with us as kind of a secondary takeaway from your article and from your learnings in the trans law class. Did you want to pivot to that before we wrap up?
Sure. Yeah. So I think one thing that I wanted to accomplish today was to teach some terms that I think are helpful. If you use language that is correct, then I think that really helps move the conversation and this issue forward. I'd say one of the biggest takeaways I took from the class was that I, as a cisgender woman, I identify as a woman, and that's what I was identified at birth. I have a lot to learn when it comes to the transgender experience and the non-binary experience. I'll include that as well. So to me, one thing that really resonated is it's important to say things like, I've included on my slide that my pronouns are she, her. And I think that can be a really helpful thing to say when you meet a new client or when you have an interaction with anyone. If you talk about your pronouns every day, it becomes less unique when someone who maybe doesn't have something that's a clear, an obvious pronoun, so to say. So if I say it and I say it every day, then all of a sudden it's not unusual when someone else says it. And so I think having that in your regular dialogue can really help to make everybody feel more comfortable. I think we're finding that like a lot of times you'll say my partner instead of my husband or wife, because if you say partner instead of the gendered, it becomes less unusual when anybody says it. So I think those kind of language things can be really helpful to make everybody more comfortable, anyone who is trans. And then I would say also ask them and use their pronouns. If they tell you they are they, them, use them. It's very low effort, and it can have a huge impact on a relationship with a person. So my biggest sort of like, if you learn nothing from the presentation today, try to make that subtle change because it can have a really big impact on people's lives.
My takeaway is it's not enough simply to refrain from committing overt aggression. There are things that we can all do to make our daily lives and the daily lives of others around us also free of implicit or microaggression. And there are active measures that actually do not require a whole lot of effort from the large number of cisgender people in our population that can make life better and more accommodating for those who are transgender. Before we close, I do have an audience participation question from our very own fearless leader, Ken Petroulis, who has tirelessly organized the writing competition for even longer than I have been involved in it. He said drag performance has been celebrated in popular culture, like the famous film Some Like It Hot with Tony Curtis and Jack Lemmon, and Tootsie with Robin Williams. Surely the anti-drag performance law didn't pass, did it?
I don't recall. I don't have that information right here, but I think some of them have passed, but I don't know by and large if the one I put in here has. But
I try not to
think,
politicize my presentations, but that is a crying shame.
yeah. Well, I think, the big picture is that I think no matter how you feel personally about being trans or that existence, that existence in life, it's still, you can recognize animus because of the fact that there are these clear indicators that it isn't about safety or any of their purported reasons. It's by the same people. They're using the same language, and anyone can recognize that as just a legal argument. And so I think, no matter what it is, if we see these patterns, you can still apply rational basis with bite to other things. I just think that this is a winning way for combating the gender affirming care bans. But I think it can be applied in a lot of ways where you can see the same actions are being taken against a specific group, and you can tie it all back to animus against that group instead of a purported reason.
Well, I appreciate you for staying hopeful. This could be one of those cases where the more you know, the easier it is to give up. And you've done anything but. You've given us tools for how to go forward. And I hope that as your career progresses from here, that you actually get the opportunity to apply this in practice. Whether you do or do not, you have contributed to the intellectual body of work that others who do will rely upon, surely. Any concluding remarks, Ms. Hinson?
Sure. So if you want to go one more slide. Yeah, so this is sort of the hopeful path that I think that if people are working on this right now, or if you have an interest in this area of law, I think that thinking outside the box and thinking about other standards of review, other ways to win that that we have done in the past, try them again, because I think we're in the era of we just need to try something, and if it doesn't work, try something else. And that's kind of my thinking is this might be the backup argument, but let's try the backup argument.
Well, there's certainly other special interests for whom that has worked.
Yes.
Perhaps more regressively than progressively.
Yeah. I'm hopeful, and I think that I researched and read Bostock versus Clayton County, and that to me was an opinion where it was not the expected result, but there are ways to win and get things accomplished if you find the right argument and you find the right path. And so I think of rational basis with bite as a path to get there. So I hope that this is something that inspires people to look into this area of law more and to maybe write something themselves. But at the very least, I hope everyone has learned something, and I hope you're open to continuing to learn, as I am open to continuing to learn about this as well. I'll say on our last slide, I have of resources. There we go. These are 3 resources that I used a lot in my article, and I think that they're very, very helpful. A lot of the transgender studies are done by the Trevor Project and the Williams Institute. So if you're interested in more information, these are 3 great places to start. Or my article. You can start with my article.
Well, Ms. Hinson, I'd like to thank you again for writing that article and submitting it to our competition. Thank you for being here with us today. I'd like to thank our audience and the rest of the committee from the Beverly Hills Bar Foundation. I wish everyone a wonderful rest of your weekend, and a happy 4th of July. Thank you for being with us today, everybody.
Thank you.